Welcome, everyone. I'm Bobby Fazy, president of InSight Law. And today we'll be talking about estate planning. And I will get started in about 1 minute. We've got a couple other people signed up. I just want to make sure and give them some time. And while I'll just slowly get us going, and the sheet that I have in front of you, you all have handouts. The sheet I have in front of you that's put up on the screen is called Selecting and Working with an Estate Planning Attorney. These are the questions that I would be asking an attorney if I were interviewing them, knowing what I know. Everyone asks about price, and that's very important. But there's about 14 other questions you should be asking. And so the goal today is just to go through the key issues that you should be considering in the estate planning process, our process, common pitfalls, common mistakes people run into, how we charge clients, how we work with clients. So what we do is not for everybody. We have a specific process, and we are good at what we do. I'll show you what we do. But again, this is about education, learning. There's a lot of different ways you can do this. And with that being said, I'll check back in towards the end of the presentation and see how we did. If you do have questions, please type them in the chat. And towards the end, I'll open it up. If you want to ask questions verbally, that's fine as well. But a lot of times you might be thinking of something. I can catch that on the fly and address that question. So you got me for about an hour and 15 minutes, give or take, is how long this takes. And with that being said, I will get started. So I'm Bobby Fazy. I am an estate planning attorney. I'm the president of InSight Law. We are an estate planning and business planning law firm. I'd say 60 to 70% of our practice is focused just on estate planning. And the other 30%, just depending on the mix, is about business planning. A lot of our clients own businesses or own real estate and the like, and they need to organize their affairs with regard to those interests. And the purpose of telling you that is that we are not doing personal injury. We're not doing family law. We're not doing other different areas. We focus on this, and you're going to find that's enough given the scope of what we deal with. And I'm a very blunt attorney. If you work with us, you'll see that I'm blunt. I'm really just bottom line. But most estate plans just don't work, okay? And how would you know if your plan worked or not, right? Maybe when would you know might be a better question. It might be too late. It might be after you're gone that it seems like it's a mess, right? But we try to take a very practical approach. So, you came here to think about estate planning. So I want you to, what we use is, I'm a visual learner, and I call it the snapshot test. So I want you to visualize the time after you've passed away and you're looking down from your cloud from above. All my clients look down. They don't look up, right? Beats the alternative. But if money's going the way you thought it'd be going and people kind of doing what you thought they'd be doing, then that's generally a plan that worked. Money not going where you thought they'd be going, people fighting, there's court, probate, assets getting frozen. Probably not a plan that probably a plan that doesn't work, and that way you didn't think how things would work out. And so, you may have an idea. The goal is for that snapshot for today to get a little bit more sharper picture on your snapshot with knowledge, knowing all the common issues. A lot of people have this notion of how things should go, but they don't know the rules of the game. I'm going to give you some of the basic rules. But before we get into the basic rules, there are some traps, typical traps that I see people fall into when they're looking to do their estate planning. They're focusing on the documents. They'll call the attorney's office. How much for a will? How much for a trust? How much for a power of attorney? How much for a medical directive? The documents are important in the estate planning world, but if you're focusing just on the documents, that's short-sighted. And what I mean by that, I use an analogy. I'm a big fan of the show, the Fixer Uppers. If you've ever seen it, it's this couple, Chip and Joanna. And if you haven't seen it, if you've ever renovated your house or anything along those lines, Joanna's the one who comes, sits down with the clients and tries to get their vision and their goals. How do they want the kitchen to look and feel, the bedrooms, the bathrooms, those types of things. And then Chip is the carpenter. He comes in with the tools and implements. Okay. And my the point of this is, or my analogy is, does anybody ever ask Chip or the carpenter what tools he's using, right? No, they would just want the kitchen counters to the end results, results oriented. I want it to look and feel like this, right? Same thing on the estate planning world is the tools are our legal documents. Which combination works right for you depends on your specific situation, your goals, and what you're trying to accomplish. You really should be focusing on your end result, not the tools, because then it's going to be short-sighted, okay? And so that's one point, one trap. The other trap is the tax trap, saying, hey, I don't have a large estate, so there's no need to do, I don't have an estate tax, any estate tax exposure, so there's no need to do planning because I'm not going to deal with estate tax. That's short-sighted because taxes are just one issue. And yes, the estate tax right now does not apply to as many people as it used to. All right. The estate tax, the federal estate tax, there's some states that have state estate tax, but I'm going to stick with federal. The federal estate tax is as high as it's ever been. You can die with up to $14 million before a 40% excise tax would be employed against your estate. And if you're a married couple, you can double that to 28 million. So it doesn't cover, it covers, a lot of people aren't exposed to it. But what are the issues? Well, that number is going to get cut in half next year, January 1 next year, automatically, unless Congress acts, right? And so you might say, hey, I'm still good with 14 million, right? But you just need to be aware of that. And we think, right, with the way the mix of the administration is, it's a Republican dominated on all three kind of key points, that they're going to extend that estate tax. Not a slam dunk, but they are. Okay. So that probably will not be a big issue for a lot of people. If it's an issue for you, good. Then you have some more planning to do and you've got more wealth to plan for, right? And then the other issue on the tax side is from the estate planning world, estate taxes aren't the only issue to be thinking about. A lot of our clients have retirement plans, a lot of their wealth built into retirement plans like 401ks, IRAs, TSPs, all of these different types of tax sheltered vehicles. And when you write your beneficiary designations on those, you're doing estate planning. So when you die, these assets are going to go to these people. And there's income taxes issues that you have to be aware of. And they just changed all the rules on all that with legislation that came about last year, or updated legislation called the Secure Act 2.0 that impacts all retirement plans. And specifically, the beneficiary designations are definitely impacted. And so you just need to get, that's an issue to be aware of, right? And who you're making, what beneficiary designations you're making, and make sure that they're right ones, because there's a lot of money usually at stake. And then the other trap that people fall into is, oh, I just want to avoid probate, and I just want my assets to go directly to the other parties, to my beneficiaries after I die, and that's all they care about. And so, yes, we'll show you you can do that. But again, there's a lot more issues than just transferring assets from point A to point B that we got to be concerned about. That's my goal today, is to show you, yes, um, here are the typical traps. Here's the thing. They're important issues to be considering. But this is some of the things that, knowing what we know, I've been in this business 20 years and just focusing on what really matters. And I've administered means our clients have died over 50, we've had over 50 deaths, 50 administrations. So I know what to look for. I've done this, okay? Our team has. And so we know how to organize affairs so that when something happens, death occurs or disability, we can have things in such a way where it's very efficient transfer and seamless to the next people in line. All right. And that's really what our skill is we're like, what's the plan? Not just here's a document, good luck. Okay. And so what I find is what's really missing is knowing all of your options. Most attorneys are still transactional, even in this field. I don't understand why. They're selling you a document, they close their file, they're going off to the next person. All right. And so you need to understand, you want to make sure you have work with someone that's counseling you on the pros and cons of your options, not just getting biographical data for you and putting them into some forms. And so a lot of people, their snapshot may look fuzzy like this because they don't know what to look for. They don't know what to ask, right? So let me show you some of the basics to give you some information to clarify that picture. So one of the initial questions I would be asking of the attorney if I was in the market for one is, how do you define estate planning, Mr. Attorney or Mrs. Attorney, right? And so, because you're getting what they will be doing for you, basically. And this is not just like in, I'm not saying just the black, like the Webster's, I don't even know if it's in Webster's dictionary, this define estate planning. This is what we use is the National Network of Estate Planning Attorneys definition. I like this definition because it covers all the issues. It kind of stands the test of time. It's been around for a while. And so let me share that with you. So I want to control my property while I'm alive and well. A plan for me and my loved ones if I become disabled, mentally disabled. And then I want to give what I have to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. So that's a mouthful, but it really covers all the issues. First, control while healthy. Shouldn't change things much while I'm healthy, alive, and well. Hopefully, I never become mentally disabled, but if I do, I don't want it to be a train wreck. Let's have a plan, contingency plan. And then when I pass, let's make it efficient. Okay. And we set the bar high, if we can pass on some life lessons and values while we're here, this is a great place to do it. Again, everyone's different. And so our job is to show you the options and you can take advantage of what you need. This planning pyramid lays out our law firm's personal counseling philosophy. Like I said, every law firm kind of does it differently. This is the way we do it. I like this approach. And basically, this approach, this planning pyramid approach, it illustrates the following. That when we work with clients, when they walk through our doors or go onto our Zoom meetings these days, that we're categorizing the issues, we're prioritizing the issues with the most important issues toward the base of this pyramid and then working our way up. So first we need to get to know your specific situation. What are your goals? What are your hopes, fears, and concerns? And then we look at the family. Are you married? Are you single? Are you widowed? Are you widower? Right? And then how are they with finances? How is their health?
Hi, this is Stephanie.
Oh,
It looks like the video froze.
oh, it did? Okay, thank you. I'll
Oh,
see.
there you're back.
Okay, thank you, Stephanie. All right, so then thanks for sharing that. And yes, jump in if those things happen. And so the family side of things is if you have kids, are your kids minors or are they adults? And so a whole host of different issues if if you have minor children than if you have adult children. If you have minor children, you're more worried about, God forbid, we both pass away, where are they going to be? That's the guardians. And then a lot of people don't realize, a lot of people when they're younger, they have life insurance that comes in, but they don't have plans for it if they were to pass away. And they just say, here's a pile of money, guardian and trustee, figure it out. So you got to think about those issues if you have minors. And if there's any health concerns or if the child has special needs, we need to be aware of that. And then for adult children, age doesn't necessarily equal experience with money, right? And so, how are they with money? How do they get along with one another? Are there health issues that we have to worry about with them? If they are married, how are their marriages? Strong, shaky? So we gotta know what I'm dealing with. What's the landscape before we can show you strategies to preserve wealth, expand wealth, and save taxes? Okay. I find a lot of people are trying to sell things to say, here's a tax strategy of the day and try to shoehorn their clients into it. There's a lot of different tax strategies. And again, it really is the one that fits your specific situation will present itself once we have a fully developed plan. And then preserving and expanding wealth, if you do have a financial advisor, that is a great way where I find in the estate planning world, and it's our goal, what we think is, hey, if the client has a financial advisor, let's make sure we're communicating with the financial advisor because they're dealing with the wealth, right? And let's make sure, and we're dealing with your family, all your family and your wealth, because we got to figure out how to pass it on. So we got to work together, and there's a lot of efficiencies there. So I'm all about teamwork, and we want to make sure that I'm not worried. I care about the plan working. I'm not going to say, hey, I'm calling the financial advisor and I spend 10 minutes. Here, I'm billing the client for 10 minutes. Okay. That's not the way we work. We don't do hourly billing on that kind of stuff. I'll show you how we charge. But the basic idea with this planning pyramid is you teach us about the family, we'll teach you about the law, and together we'll make the plan work. Right. Okay. And so that's the pyramid. Here is the 4 keys to an effective estate plan. I like bullet points. I get asked to review estate plans all the time. If you have an estate plan, if you can check off all of these 4 points, the last one has a couple of sub points, then you're good. Okay. And so the first thing is I look at the documents and I look at talk to the people like, did these people get good personalized counseling? Or is this basically word process document with just some biographical data put in? And so I'm going to give you kind of some examples in later slides of what I mean by counseling versus word processing. And yes, I spelled counseling with 2 L's. I'm trying to make a point there that there's something more that the attorney should be bringing to the table than, just the word processor, that they have some advice, that they have some knowledge to impart on different scenarios. And then the second key is proper asset ownership. I would say this is one of the biggest pitfalls in estate plans today is that people have their assets improperly titled. And the stakes are high because what happens when people die, and especially financial institutions, especially banks who are ultra conservative and always worried about getting sued, they are not going to make it easy for if you die to get the next person in line to be able to have access to the account to follow through with your instructions. Okay. And so you have to make sure that your assets are titled in such a way that your instructions actually apply to your assets. And there's only 3 ways you can own your assets: your individual name, jointly, and by contract. That's it. Okay. And yes, there are subcategories of the joint ownership and contracts, and people get stub their toe there, especially the contract one, because IRAs are contracts, 401ks are contracts, banks transfer on death designation. You need a PhD in form reading, okay? And so we deal with that all the day. We have 2 paralegals, they're called funding coordinators. I'll explain that later, that just deal with this type of paperwork all day. And you have to, every type of asset you had has a different rule for it. Real estate has a different rule. Financial accounts have different rules in IRAs. And so this gets overwhelming for people at death. They didn't plan for it. And these people are in the grieving process and the families are getting hit by all these things, and it's overwhelming. And so what we are all about is let's get that set up front so it's smooth down the line. Okay, let's do the heavy lifting up front. And then number 3 is let's have an agreement to take a look at this every so often, right? A formal review process because things change. I know things are changing next year because all the tax laws are in flux right now. All the old tax laws are sunsetting. They're trying to fight over what's going to happen. So we know that's going to change. Financial situations change, different techniques. So I'll show you our response to that. I find the biggest um, objection with the formal review process is that, typically once people get their plan set up, a lot of attorneys will just charge a flat fee to set up. But once you're done that, you're on the clock, and every penny, every copy you're paying for. And we're like, let's figure out a way that let's think about this where we want the end result for the plan to work. And how do we make this work for the law firm and the client where it's not nickel and diming? So I'll show you our response to that, how we work with clients on that. And then number 4 is a controlled transfer process. You probably wouldn't be listening to me today if you weren't looking for some type of controlled transfer process. So I'll be very blunt, okay? If you were to die today, how prepared is your family if something happens to you today? right? And what I mean by that is, would they have any idea what to do, how to do it, or how to pay for it? Or would it be a complete mess, right? And so, okay, so those are the four things. So how do we get there and what do we need to know about? So there's five major ways to plan that I see out there in the world. You can do no documents. I'm not going to recommend that, but I'll show you some examples of how that works, okay? And then you can do what's called a will and a POA. In the estate planning world, um, there's a lot of acronyms. I didn't come up with these acronyms, okay? But you need to understand them if you're in there. So last will and testament, that's a legal document that takes legal effect at death. There's no planning during life with the will. It only takes legal effect at death. It requires the family to go to probate after death. That means the court process after death. And it is cheaper upfront to do a will because you're leaving all the work for the family to do at the end. Okay. And there's no disability planning for a will because it's not in legal effect until you die. So they add what's called a POA or financial power of attorney if you have disabilities or something. And then they have a financial power of attorney that designates an agent to make financial decisions for you. Now, there's two flavors of financial powers of attorneys. There's a general durable power of attorney, which is effective immediately. And then there's a limited power of attorney, which is effective only after you've been determined to be disabled. You see the difference? Okay. And then you have a healthcare power of attorney or an advanced medical directive. And the advanced medical directive is a legal document designating an agent to make healthcare decisions for you. And that one only kicks in if you're not able to communicate with the doctor. The doctor is going to go to you first. If they can't communicate, then they're going to go to that. All right. And so that's a simple will package that people often get with a lot of firms. We really don't specialize in those unless we're doing it maybe for like our clients' kids. But that's very transactional. And I would say go to LegalZoom. Don't pay an attorney for that. It's just documents. They're not doing much behind that. There's no really heavy lifting with that. The next one is a will with a testamentary trust and power of attorney. So now I'm introducing you to this trust. And so stay with me. Last will and testament, a testamentary trust is one that's created after death and with court oversight. I don't know why you would do that. Okay, but I do know why people do that. Usually younger people, they can't afford a trust. And so they buy a last will, they get a last will and testament. They have minor kids. Well, they die and their kids are minors, the money can't go to a minor, so they put this basic trust provision in this will, slap that in there, and God, good luck administering that. But it's cheap up front, okay? And so then you've got the simple trust. And I call these bare bones trusts or trusts, and that's one you do create during your lifetime. And a trust is just a contract, but these simple trusts are ones that are done with very little counseling behind it. It's basically a word process document. And I'll show you the comparison of that. But the big difference between a trust, revocable trust, one that you can amend and change during your lifetime, and a will is that the trust takes legal effect right when you sign it. The will doesn't take a legal effect till you die. And then the modern approach is where our law firm tries to be. It's the end result we're focusing on. The documents are just part of the deal. What the documents, what assembly or organization of documents that we need depends on your goals. It depends a lot on what kind of assets you own, okay, and what you're trying, what you're trying to accomplish with that. And so those are the kind of ways that those are the ways that you can plan. And it's really the modern approach really just deals with the process so that when someone dies, there's a plan and there's some resources that the client's family can call to get them through that. Okay, and they're ready for it. And that's what we try to focus on. All right, so the challenges on the estate planning world, mental disability, health with healthcare, people are living longer. And so people are living, and there's a lot of issues when people live longer as far as their cognitive abilities and their physical abilities. So how does that work? And what do we need to be think about there? Asset transfer on death. Let's make it as seamless as possible. Let's not make it where the financial institution says, no, we're freezing the accounts, go get a court order. We want to minimize taxation to the greatest extent possible, obviously. And then let's achieve your personal planning goals. If you want, a lot of our clients like bloodline protection. Hey, when I pass away, I want it to go to my kids. and when they pass away, it goes down to their kids, not to their spouses, or may want to go to their spouses, or I want to leave money to them, but protect it against creditors, or so we have different goals that we want to look at, and we'll show you some personal planning goals. And then the three-step strategy. This is our approach. So our approach is as follows. The way that we approach this is there's three kind of focus stages. One is the first stage is developing the plan with counseling-oriented planning partners. We're trying to empower this design. And so giving you options. And then also, if you have a financial advisor that you work with, making sure that we're working as a team with them, or accountant, or however that you have trusted advisors. Then we want to empower that legacy by that maintenance plan, is having some type of maintenance or just having some touch points to make sure that the plan is on track. And we have certain ways to do that, and I'll show you that. And basically committing yourself and your family to a formal maintenance and education program so that when the eventuality happens, the death occurs, we can empower the inheritance by securing appropriate assistance to transfer your wisdom along with the rest of your wealth. So the approach is not, hey, let's get some documents to this client and let me go find the next client and just close the file on it. It's let's set this plan up with this client. Let's do the follow-up work. Let's stay with that family so when the eventuality occurs, we're in the best possible position to help them when they need it most. Okay. And with that kind of lens difference, it changes all of our processes in the firm and our goals, and it's all client-centered and it's all results-oriented. And that's all of our systems are for that. All right, so then here are some traps to look out for, and let me give you some education. So if your only goal, if you're going to do no documents, right, and your only goal is to avoid probate, I will show you some examples of how to do that. Now, you have to do this at your own risk, but it is definitely a way to avoid the probate process. And probate, if you don't know what it is basically a government audit of your affairs after you die. It is completely avoidable. So here's some of the rules. Anything that you own in your individual name at death equals a will. My clients love formulas, my engineer clients. Equals a will equals probate. So think of it. So even if you don't have a will, you have the government's will. And anything that's owned by your individual name at death goes through the probate process. So how do you avoid probate? Don't have anything in your individual name at death. Okay. So what do? You title everything as joint tenants with right of survivorship. What is that? It's a legal form of ownership where when one joint owner dies, the asset will go outright to the surviving owner by operation of law. You just take the death certificate to the financial institution. Great. Let's play this out in reality now. So I'll introduce you to my favorite cast of characters, Bill and Mary sample. And let's say Bill and Mary have 2 kids, okay? And let's say Bill and Mary decided to say, no documents. I want to just do everything joint tenancy. All the accounts that they have are joint tenants with right of survivorship. And I always knock off Bill first, and it's just statistics that guys pass away before the girls, but do whatever you want in your plan. So let's say Bill dies, everything is titled in joint tenancy, everything goes to Mary. Now all the assets are in Mary's individual name, right? So now that Mary is in the grieving process, and everything's in Mary's individual name, we want to burden her with figuring out how to do all the planning so that all the assets could get to the next generation outside the probate process. Not a good plan. Why don't we just do that up front? Okay. And if you think you're just going to add the kids to the accounts, think again. When you add someone to a joint account, they are owners. They can do whatever you could do. And all their baggage is your baggage. They get sued, you get sued. They get divorced, you may have those assets at risk. So not a good way to do it. Okay. And then there's something called transfer on death accounts. The transfer on death accounts are the banks or the financial institutions contracts that say when this person dies, pay it out to these people. So you better read the fine print on the financial accounts. They're not in your favor. And they are suitable in some situations. We use that sometimes, but it's not a hammer that you just do it for all the accounts, okay? Because you're going to miss out on some protections that you can build into the plan when one spouse passes away in situations, if they're in a married couple situation, or even if you're single, how you can pass assets on to a beneficiary. And then planning with the box, these are for those beneficiary designations that you fill out, like an IRA. If you're familiar with it, a lot of our clients have IRAs and 401ks. There's on the form, the application form, you have to fill out who the beneficiaries are. These are the people receiving the money at death. And there could be a lot of money there. So you better make sure you fill that out right because with the new laws, there's income taxes that are embedded. And a lot of times, our clients want the protections of a trust. And so to be able to integrate that with the plan is very important, but it's delicate and you need to work with someone who knows what they're doing on that. And so those are the things you can do and avoid probate, but what are you giving up? Okay, I got around the probate. What are the problems? Well, number one, these are the real issues that you're not really addressing when you deal with that. Catastrophic illness protection, remarriage protection, creditor protection, divorce protection, values promotion. These are some examples of things that are routinely we see are missed if you are just being short-sighted with the planning. So what does disability, catastrophic illness protection mean? So let's say you did have that big illness towards the end of your life, right? Stroke, Alzheimer's, dementia. My question to you is, do you have an opinion if you'd rather be taken care of at home or in a nursing home, or you don't care, right? And if you have an opinion, where in your legal documents does it say what your opinion is? And I talked to somebody who said, "Yo, I got that. I got that covered. I have what's called I have an advanced medical directive or a healthcare power of attorney." And that's a great start, okay? But a healthcare power of attorney or advanced medical directive is a legal document designating an agent to make healthcare decisions for you when you can't communicate them to the doctor. But it's pretty boilerplate. It just says you can check me into a hospital, you can check me into a nursing home, you can keep me at home and bring home care in. You decide, healthcare agent. So if it's that important to you, where is your instructions? And what we do is we just have checklists. We don't give you a blank piece of paper and say, tell us what you are. We've done this before. Here's a checklist. Here are your options and help guide them in those various situations with regard to that. And so that's one, big issue. And if you don't care, right? And if you don't care if you want to be taken care of at home or a nursing home, from personal experience, you're not doing your family any favors by leaving them in limbo and having them trying to guess. It's a tremendous burden. My dad loved us. But he was really quiet with his estate planning. He didn't work with me. It's one of the reasons why I got into the business. And we didn't know what he wanted. And he had dementia when he was older. And so we were guessing how long he wanted to burden my mom with the healthcare at home versus, hey, if I need round the clock care, maybe he didn't want to burden her, right? And so these are things to at least think through ahead of time, and especially the financial issues. Hopefully your family never has to deal with that, but if you don't plan for it, and just for the contingency, it really hurts and you're coming out of left field with it. That's one issue. And so the idea is, number one, would you rather leave instructions for your own care? And then another big one is when you give up control of the finances. Again, hopefully you never have to be in this situation, but there was a point when my dad was getting scammed, okay, by these vultures who would try to take their money either online, Apple payphone stamps, calling the house, and he was sending checks to the wrong people, okay? And so it's a really big deal to give up the checkbook. And a lot of people, when you're far down the way, dementia are paranoid and they're fighting it, right? And so we have a process. There's not a perfect process, but it's proactive and it mitigates the risk, at least. It helps us. And the process asks three critical questions. When am I disabled? Who do I trust managing my money when I'm disabled? And what can they use the money for? So hopefully you never become disabled, but let's plan that So when am I disabled? It's not like most legal documents say when two licensed physicians anywhere in the world say I'm disabled, then I'm disabled. I don't like that definition because you just don't wake up with one day with dementia. So, and is it any doctor? Is it your doctor? And so I like it when it's if it you need a medical opinion, so you need a primary care physician, it could be your doctor. Now again, I get it this day, if you get 20 minutes with your doctor and if they would even recognize you if they bumped you into the supermarket, right? But the idea would be that we have a family component as well. So if you're married, a common, what we call disability panel, and these are not people making healthcare decisions. Their only job is to decide if you can effectively manage your financial affairs. So usually it's my doctor and my spouse, or my doctor and my kids, or doctor and a friend, right? And you can also add in a second medical opinion if you want. But we think about that. So you're comfortable about, yeah, I trust these people. And if that's triggered, then if we have assets in this cup, then transfer my assets and the trust. I'll introduce you to the trust. Think of it as like this cup. It's a great vehicle to consolidate all your assets. There's some exceptions. And you move that on here. I trust this person and then follow these instructions. And again, I'm not going to give you a blank piece of paper and say, what are your disability instructions? So there's things we've done checklists, and you can say, hey, maybe you can renovate the house because I don't want to go into a nursing home, or I've seen these places, I like these places and the like. So that is the when, who, what analysis. Okay. This is not a presentation about Medicaid. I just wanted you to be aware that catastrophic illness planning, where people are going into nursing homes and nursing homes are just the costs of nursing homes are skyrocketing, where it could be anywhere from $10,000 a month. I've seen it as high as 40,000 a month, and it just blows through people's retirement plans. And so Medicaid is like the payer of last resort on these nursing homes or care on those types of things, where you have to show you are penniless basically to qualify. And the new administration is trying to cut that back too. So it may not be as easy to get on Medicaid, but through trust planning, people are able to do that at some point. Again, I'm just saying it's out there beyond the scope of today. Then the second issue is remarriage protection. So remarriage protection, I don't spend a lot of time on it, but let's say the Bill and Mary sample example, and let's say they have the two kids, right? And let's say they have what's called the I love you wills. Very common planning technique. The I love you wills say when Bill dies, everything goes to Mary, right? And when Mary dies, everything goes to the kids. And if Mary predeceased Bill, it goes the other way, right? Very common. I see that all the time. So let's play this out on this issue. So let's say Bill dies and leaves everything to Mary, right? And so now Mary goes to the tennis club and meets Bo, the tennis pro, and they fall in love and get remarried, right? And let's say Mary's will says everything goes down to my kids, right? And let's say Mary predeceases Bo. Even though Mary's will says everything goes down to kids, does Bo have a legal right to those assets? Yeah, in all 50 states, he does. They want to give spouses rights. It could be anywhere from a third of the estate to a half of the estate. Bo can say, I don't care what the will says. I'm a spouse. I have rights, right? The other thing that's an important concept is titling takes priority of how the legal documents are structured. What does that mean? So let's say Mary's will said everything goes to the kids, but Bo, right? And maybe let's say Mary has an IRA, and a knee-jerk reaction when there's a married couple has an IRA is let's be the beneficiary of the IRA should be the spouse. That's a contract, okay? And so those assets, the IRA assets, the custodian of the IRA does not look at the will. They just look at the beneficiary designation form. Goes to Bo, going to Bo. How do most married people own their accounts? Like that thing called joint tenants with right of survivorship. So if they have any joint accounts, all those accounts go to Bo. They don't go down to the kids, right? So if there was a way that Bill could leave his assets to Mary, she could use it for whatever she wants during her lifetime. But when she passed away, it had to go down to the kids. Is that something that's worth spending some time talking about, right? Is that counseling? Is that word processing? Again, my goal is just to make sure we're raising the issues and heading a lot of these issues off at the pass, right? Creditor protection is a big issue that people seem to revolve around. And there's a lot of misunderstanding about creditor protection and trust, and hopefully I'll be able to dispel those myths today. So the example I'll use is my school bus example. So let's say in this story, let's say we'll use Bill and Mary as example. Let's say Bill is dead in the story, and let's say there's no creditor protection for Bill during his lifetime. Okay, and so when Bill passes away, there's a couple different options he could do to leave his assets to his loved ones, right? And let's say that when we're talking about creditor protection, let's say that Mary, after Bill died, is all distraught. And she's driving down the road on a day that's kind of pictured here, where it's kind of slick out there on the road. And she's not paying attention. She runs a red light, bam, hits a school bus full of kids. Horrible facts. Let's say one of the kids dies. She hates herself. The world's against her. You can't give it. There's not enough insurance money for hurt and killed school children, right? So I'm showing catastrophic creditors. And again, I'm not professing this in any way, right? Some of you say you should say it was a school bus full of lawyers. That way, it's not as bad. But the idea is there's catastrophic creditors. That's all I'm trying to highlight. And so let's say that Bill did no documents, right? Entitled everything jointly. So all those joint accounts and all those at the house and all those things are titled jointly. When Bill dies, they go outright into Mary's name. If Mary hit the school bus and has creditors, all those assets are subject or exposed to Mary's creditors. No creditor protection at all with that. The second way she could have done the planning is she could have done a simple will. And when the simple will says when Bill died, or he could have done a simple will, when Bill dies, everything goes to Mary. Outright in her own name, all those assets are exposed to her creditors. Those are all gone. Third way they could have done it is by contract. They could have said, let's say a life insurance policy that's not worth a lot while Bill is alive, but turns into $1 million when he dies, and he writes Mary's name on the beneficiary form. She gets a check for $1 million, puts it into her account, hits the school bus, gone. And then let's say that Bill did a trust, but let's say he did one of those simple trusts. So those, I call them bare bones trusts, that did very little counseling, and it just said, when Bill dies, everything goes outright to Mary. Same problem. Everything's outright in Mary's name when he died, subject to all of her creditors. So let's try to do the planning again. What if Bill could have done it this way? What if Bill could have left his assets to Mary? She could have used them for whatever she wanted, but if she hit the school bus, it's protected from her later creditors. So let me say that one again, because that's important, and I want you to connect the dots. Bill could use the assets for what he wanted, but Mary could use the assets for what she wanted, but if she hit the school bus, protected from her later creditors. So remember that definition of estate planning. I want to control my property while I'm alive and well, and then I want to give what I have to whom I want, when I want, in the way that I want. So my question to you is, how many of you would like to leave your assets to your loved ones that way, protected from their later creditors, right? And how many of you been asked that question before, right? Is that counseling? Is that word processing? Did you know you could do that, right? And again, I think the lawyer's role is just to raise the issues and then give you the pros and cons, and you decide. Most of our clients like it. They say, yes, that's a great strategy. If there's something to protect, let's do it. Divorce protection, I don't spend too much time on that. It's kind of like creditor protection, but it's really more like bloodline protection. The idea would be, how would you like to assure that the assets that you leave to your beneficiaries, could be your kids, right, stays with them if there's a divorce or something or anything like that, rather than go with any new outlaw. There's creditor protection on the things that or divorce protection on the assets that you leave to your beneficiary, so spouses can't get into it if there's a divorce and the like. Values promotion, I use what's called my babysitter story. This is the non-material wealth, right? And the idea of this babysitter story is, like when my daughter was like 3 or 4 years old, and we were trying to go out for a nice, relaxing evening for a dinner and a show, we hired our first babysitter. If you all, then you have kids that have done this, you probably can see kind of what have similar situations where you're giving all the instructions for the babysitter, and they're just going away for one evening, right, for a dinner and a show. We're going to be at this restaurant. She's not going to want to brush her teeth. She's going to want to stay up late. If you read a book to her, read every page, because if you skip a page, she knows. I don't know how she knew. Our neighbor's information is here, right? All these instructions, and we're just going away for one evening. My point is simple, is that would you agree that we leave more instructions for our loved ones when they're little, and we're just going away for an evening, than we even think about leaving in our estate plans when we're going away for a lifetime, right? And I'm not just going to give you a blank piece of paper and say, give us your values. If we see places where that makes sense, we'll say, hey, you may want to consider this. And so the idea is, I call this like going to the trip to the eye doctor, where we're showing you different options, although I'm always guessing with that. But the goal is we're going to narrow them down to like one or two, and we'll work together to co-create the plan on all those issues. And we find other issues as we go through the counseling process that might be specific to your family. So that's kind of a glimpse of how we do the setup of your plan. And then the maintenance. Okay, this is the one where this is where we distinguish ourselves from a lot of firms, because they don't have a formal maintenance program. And so we've been doing this for 17 years, and we're strong on this side of it. And early on in my career, I was focused on teaching prospective clients and clients, hey, it's important to update. I'm going to give that one to you, that you get that the plan should be updated. If I'm not going to die in the next year, things are going to change. The laws are going to change. My situation, 15 years from now, things are going to be a lot different, right? So I'm going to give you that you get that, and that's what I was like. I realized I'm focusing on the wrong things. People understand that. They just don't want to pay for that. They don't want to do, and how can we do this so it works for both? And so the way that we do it is as follows. And so we do have a formal maintenance program. And so now we're going to get into a little bit of the fees now. But we do have a maintenance plan. And so what do you get for our maintenance plan? It costs $1,250 a year to be part of our maintenance plan. What do you get for that 1,250 bucks? I'm not going to nickel and dime you for phone calls, emails, faxes, letters, copies, word processing amendments, someone moves, someone's names change. I'm not nickel and diming on that stuff, okay? The fourth one is probably worth the fee on its own. And you need to understand what it means. A lot of people don't understand what it means. Annual funding double check and ongoing funding support. What the heck is that, and why do you care, right? Funding, I didn't come up with the term, okay? I'm just playing the game. Funding is if this cup was your trust, and the trust, like I told you, is just a contract, okay? And so the idea with the trust is that it only works for the assets that you actually put into the trust. So funding is actually putting your assets into your trust, okay? And that's all about the titling and the paperwork and all the detail work that most firms aren't doing, all right? And so this annual funding double check assumes a lot of different things. And this report that I'm going to show you is a really important report for our firm, because it really makes when someone dies of the administration, there's a disability, it cuts a tremendous amount of time and expense off of it. And so this asset review report is a report that just basically itemize all your assets so that you get hit by the bus. I'm not playing Sherlock Holmes to go find everything. I hit a button, I know where everything is at, I know who to contact. I know I'm not going to go through probate and the like on the assets. And so the way that we do it is a check mark means we verified that the asset, RLT, and we would teach you these things if we work together, is revocable living trust. As though that's in Bill's trust right there. I got a piece of paper in my file. It's not going to go through probate. So we check those things off. So the annual funding double check is we send this report to you each year, and you tell us the new values, if you sold something or if you bought any new assets, right? Because things change. And then also, why didn't we get this Bank of America updated signature card? This is not checked off. It's not verified. That could go through probate, okay? So we want to make sure that we get all the assets correct and all titled properly. And so that's what the annual funding double check is. And funding, okay, a lot of people don't understand what funding is. It's like your bank account. It is as basic as going to the bank and re-registering the account in the name of the trust so that when you die, the trust controls versus, oh, this is going to go through probate, okay? Or it's going to go outright to this other person. No, it's going to go in trust to the next person. Um, with real estate, it's deeds, putting it in there. Every asset has its own form. And that's why most attorneys don't do this, because they don't have a way to make this financially work for them. So they charge hourly if you want them to do it, or they might do the deed for your house as part of the package. But it's very tedious to do all the IRA beneficiary designations and the like. But it's too important, because if you do a trust, the number one pitfall with the trust is that it's unfunded, that not all the assets that need to go in the trust are in the trust. Because if it's not in the trust, those assets, the trust doesn't control it. And those assets go through the probate process. So why did you buy the trust if you're not going to take the time to do the follow-up work? So when you're comparing fees, and when I go through fees, our fees are different than other firms because we're not doing the same thing. They're doing documents, and that's it. We're doing counseling and documents and then putting the assets in as well, or coordinating. We're going to need your help, okay? So it's teamwork, because we can't go to the bank for you, but we can get you to the goal line, and we can fill out a lot of the other forms. And if you're working with an advisor, that's great, right? But that takes a lot of time, and we have not one, but two funding coordinators. These are paralegals. Their job all day is to put that in. Okay, we're probably one of the few firms in the country that have that, but other attorneys that have that are part of the national network of attorneys, and there's about 50 firms like us. We have the similar process across the U.S. on those types of things. So that's the annual funding double check, and then ongoing funding support, right? So hey, I'm buying an asset. Call us up. Let's work with the title company up front, or work with the investment company up front, or hey, if you're going to open up a bank account, open it up this way, because it makes it a lot easier to just do it up front than clean up the mistake that you do. You do it and try to fix it, and you never get around to it. All right. And so almost everything needs to go into your trust if you're going to do the trust work. Now, there's one major asset, I'm not going to get into too much, that I don't want you to leave here saying, the attorney said you got to put everything in the trust. One major asset we don't put in a trust is your retirement plan, your IRA, those types of things. If I were to put that into your trust, that change of ownership is considered a distribution for IRS purposes, and that's when taxes are due. Don't want to do that to you. I want to mitigate your tax issues, right? I don't want to exacerbate them. So that we work around those with different things. But funding those retirement plans, certainly want to look at those beneficiary designations and make sure they work and that they're done right according to your goals. Big, big, big point. Annual funding double check and ongoing funding support. Okay. And then also as part of the maintenance, just for in year one, we will do a family meeting at no additional charge within, as long as it's done within 6 months of the signing meeting. And we'll go over the plan as high level or as detailed as you want with whoever you want. Every year, as part of our maintenance plan, we have an annual group client meeting. We do it on Zoom. We do it in January and February. What I talked about this year at the program is what the new administration, the new presidential administration plans to do, how that impacts your planning, the tax issues you need to be aware of, what's going on with the law firm. We added another attorney and another paralegal, and just getting comfortable, people, big picture meeting with our clients. And it's about an hour and a half, 2 hours each year in that time frame on Zoom. Every 3 years, we're actually going to update your legal documents in smaller group format. And we have a report that we use that facilitates this. So we have two main reports in our firm. One is for the assets, and then one are for the instructions. This estate planning review worksheet is like your cliff notes or executive summary of the key provisions. You want to make a change to your trust. We give you this document. We teach you how to work through it. Yeah, I want to make a change, or I don't want to make a change to my beneficiaries. You are able to communicate very efficiently with a law firm by filling out this report, sending it to us. It could be no changes. And then we put the legal technical changes. Ah, these are the new tax law changes. This is what it means. Boom. And we're off and running. So it's a great process, because with that $1,250 fee, we're trying to provide a lot of services, but keep the cost down so we can get things updated for you, get assets titled, make sure we're coordinating with that so it works for the law firm. And that 1250 by no means covers our overhead. It is a loss leader, but what happens is we get referrals from other clients and the settlements are smoother. So it makes a lot of sense. We're getting to the point where it's breaking even. And so we're at year 17. It's very hard to implement those. In the first 5 years, we were figuring out our bearings, but now in year 17, we are good and we feel very confident um, with our um, with our maintenance process. And so that's what that means, the group document updates. And then the group educational programs on different topics. The one that's most widely attended is the trustee training program. In our client dashboard, there is a required training in 911 info for beneficiaries and helpers. Basically, it's what to do when a loved one becomes disabled, what to do when a loved one passes away. I do this live every year or on Zoom the Saturday before Thanksgiving each year, and then I throw it up on then I throw it up onto the website afterwards. And we do different topics on different things as the client with the client's needs and with um, like when new things come out. So the Secure Act really impacted a lot of our clients because we have a lot of clients with a lot of wealth built up in retirement plans. And so they wanted me to do a program going through the ins and outs of that. Not everyone went to that, but those who are interested in that, I went through the technical aspects of it. And then it's on our website, boom, if you want to listen to it. And then DocuBank membership is like carrying your medical directives in your back pocket. And so the DocuBank side of things, again, we're trying to be, let me make sure I'm showing the right screen. So we're trying to be where it's very practical. So DocuBank, all of our clients will get a little card. Let me just grab this. I'll show you mine right now. And the card looks like this. And after you sign your healthcare directives. And so the idea is if someone has the card or the member number and PIN number, you can access your medical directives 24 hours a day, 365 days a year. And I'll show you how quickly you can pull these down. Or there's an 800 number that the medical care provider can call, and it'll automatically get um, um, sent to the healthcare provider. So that's the 1250. You also will have, I got to put that on our sheet too. All of your legal documents will have copies on your portal that you have access to 24 hours a day, 365 days a year. You'll get the paper binder, you get the nice binder with your originals, but all of those will be on your portal as well, and you'll have portal access. And so the maintenance plan is 1250 a year. In year one, to get you set up on the maintenance plan, to set you up on our portal, set you up on DocuBank, get everything verified on the funding, we charge $2,000 for the setup and then 1250 a year afterwards. And then you can drop off at any time. If we're not providing value, if you don't see we're valuing, you can drop off. Our renewal rate is from last year is 96%. So we have a very high renewal rate. Very few people drop off. And so we have a very strong process on that end. That's our maintenance plan. So let me go back and kind of summarize. That's how our step 2 looks like. And it's just a few hours a year that you see on your end, but we're doing things in the background, okay? The asset review report, making sure that that's up to speed and good, because that's number one. We want to make sure there's no probate or this plan doesn't work. We want to make it smooth transfer of the assets. The estate planning review worksheet, making sure that we can communicate on any changes very efficiently. Every year, annual client meeting, sprinkle in the client update program every 3 years to update the documents, as along with the family education training, okay? And so that's going on in the background, and that's what we're doing to check the vitals to keep the plan up to date so that when something happens, we can secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So what does that step 3 look like? A lot of people don't understand what's involved with the administration. And so one of the things that our clients want and what they think of as appropriate assistance is let's control the costs on the back end. And frankly, people don't have no idea what the cost of administering an estate or trust is. And I will show you, I'm going to give you some education on that. But let's see how we can control costs. One way to control costs is full funding. If I created a trust and put everything that I could into the trust, full funding reduces costs after death because when you die, we're not going through probate. We're transferring the assets. Now, there's work to be done, and I'll show you what we do generally, but we're not on the court schedule, okay? And that should reduce costs, and that should translate into a cost savings for you. If it reduces my time and expense, should talk. The other is proactive trustee and beneficiary training. So just making sure that the people who are next in line know their roles and know what to do when the time comes. Okay, they just need to be just some basic education. That's our events that we do proactively. And the idea is instead of doing education after someone dies during the grieving process, one-on-one, when it's hard for people to absorb this stuff, let's do the education in group format before something happens to keep the cost down. That's the idea of those Saturday before Thanksgiving events and putting it up on our website is what's a trustee, beneficiary, what do we need to know about these trusts and the like. And then a proactive engagement approach would also control costs. What does that mean? So if you're on our maintenance plan, when you pass away, we will agree to do the administration at predetermined rates, which you'll see is below market. But we can't lock your family into using us. Your successor, trustees, your successors would have to hire us. Everyone does, but they don't have to. They're not locked into anything. I can't ethically bind them to use us. Some people want me to, but we can't. So those are the things to be understanding with regard to the cost side of things. So now let's look on, let's dig into the costs and the fees and the like. And so what is funding? I think I hammered that in. Funding is moving all of these assets into your trust so that the trust controls when you pass, okay? Or if you become disabled and can't manage it on your own. So full disclosure of those costs. There's 3 costs to every estate plan. The cost of the initial counseling and documents, the cost of updating or failing to update. I find most people don't update, and the cost after death, which is people don't look at that. Everyone's focused here, and you got to compare apples to apples there. But let's start with after death because I find most people don't look at that. So let's look at the fine print. So I'm just going to use, I'm just giving you samples of certain jurisdictions. They're all the same generally. Some jurisdictions are a little cheaper than others just because where you're at, but I'll show you the idea. This compensation schedule, this is Virginia's. This is if you go through probate, okay? This is if you did the will plan and your assets go through probate, or you did a trust and didn't fund anything in the trust or funded very few, any assets go through probate. This is what Virginia says. It says, this is what an attorney can charge to do the administration of the estate. And let me back up. Typically, the will say, if there's a married couple, the spouse is my executor. The spouse has no idea what to do. They hire an attorney. The attorney will charge within these ranges. Because if you go within these ranges, those are kind of rubber stamped and those are approved because those are statutory guidelines. If you go over that in your attorney, you better give them a good reason. So I find they're usually right up on that line. So while the assets are tied up in probate, any income generated, so if you have a rental property, the rental income, if you have stocks that pay dividends or interest, all that income, 5% of those income receipts until the probate is closed, that's a reasonable fee. And then and most probates, they're going to go on for at least a year. Some go on for 2, 3, 4, 5 years more. And then principal, the underlying principal, the assets, if you had like $1 million worth of assets, on the first 400,000, they can charge 5%. That's 20 grand. The next 300,000, they can charge 4%. That's 12 grand. The next 300,000. So you get the idea. It's on a percentage scale, and that's how it's done with the wills and the probates and all that. Great. If you live in Maryland, Maryland's forms, these are all buried, and these are all part of your packets. They say, hey, the first 20 grand, you can't go over 9% because there's going to be some initial startup. But after that, you can charge 3.6% is okay for the attorney to charge on those assets. There you go for Maryland. And then I got the Florida statutes. and it says trustees attorney's fees. So now I'm talking about a trust. And a lot of people, there's two teaching points why I put the Florida statutes in here. Because Florida is ahead of most states when it comes to trusts. Because Florida has a lot of seniors that live there. Would you agree? Some people call it God's waiting room. So you just drive into Florida, there's like a living trust billboard. They're way advanced on the trust side of things. And what they've done is they put a statute in there in their code that said, you know what, attorneys, we are going to put a statutory cap on what you can charge to do a trust administration. So there's two teaching points that I want to get across to you. And a lot of people don't realize this, so hopefully this will help you. Number one, when you die and you have a trust, a lot of people think there's no work to be done. Hey, I did a trust. It's automatically, everything automatically goes to my beneficiaries. The financial accounts automatically go to them. The advisor doesn't even know. The IRS doesn't even know. All my stuff is just been. That's not reality, okay? Death is a major life event, and you just think about how many usernames and passwords you have. We don't want them, right? But think about you need closure. The family needs closure on every relationship you have, okay? The big ones are financial, the government, the IRS, local, federal, and then all these online crap, right? So all of that has to be dealt with, right? And so that's what, so the fee, whether you do a will or a trust, there's gonna be work to be done when someone dies. That's just reality, okay? It's just whether you're on the court schedules or not. And I don't like to be on any court schedules, right? And then Florida, because it's such a strong consumer protection state for seniors, there's so many of them down there, it kind of gives you an idea of what the market rate is for attorneys to do an administration of a trust. These are not public records. This statute is, but public records, like for probates, the attorneys, what they charge for a probate, those are public records. They file an account, you can find out what your neighbor's accounting was and all that. That's public. Trusts are private, and so you just need to know if you have CPA buddies, they can tell you because it's a deduction on the estate tax return. But basically, this paragraph 3 tells you what the market rate is, and then I'll boil it down for you. Basically, the attorney could charge what they could have charged 75% of what they could have charged on a normal probate. So you get a 25% discount, right? And then the Florida schedules are listed here and they look lower. So this is Florida's probate schedule. And so it's 75% of the schedule. So it looks lower than the other states because Florida's so strong on the consumer protection for seniors. So it's between 100 and 900,000. It's not 5%, it's 3%. 25% off of that. 2.5% between 1 and 3 million. 2% between, so you get the idea, still percentages, those are lower. So probably more than you ever wanted to know, but I'm giving you the background. All right, so this is how we charge. I'll give you range. I don't know what specifically we would charge you. I can tell you you'd be in this range. I will tell you, you don't pay a thing until you know exactly the scope of work. And we will give you a specific fee quote because I can't tell you that unless I know how your assets look and your goals. If you've got property in 5 different jurisdictions, that's different if you have property in one jurisdiction. If you've got a timeshare or individual stock shares with computer shares that are not with an advisor, those are different things because we're going to do all the detail work, right? And so I can give you a range. And so since we just talked about the settlements on death, we charge 1.5% on the size of your net estate, only charge at death and only charge if we're hired, right? You just saw 5%, 4%, 3%. We're going to be below that because of our maintenance plan. Our maintenance plan drives down that fee because if I know where everything is at and it's fully funded and I'm not going through probate, makes my job easier, should translate into a cost savings for you. If I have an educated family that knows what to do at the appropriate time or doesn't blow things up and move things in the wrong place, makes my job easier, translates into a cost savings. If you have a financial advisor that we're working with, then that also makes things easier to set up the inherited IRA accounts and trust accounts and the like. So those things during your lifetime make it easier and drive that down. And so that's what the maintenance plan is for. That's the $1,250 a year and the $2K to get you set up on all those things. The upfront cost of setting up the plan, and this is for non-taxable estate. So I told you, currently the estate tax. So if you're a married couple, this is for married couples for base foundational planning up to 28 million. And if you're single, up to 14 million. So that covers most people. That includes the legal documents, and the typical legal documents that we will be using are your as a trust. I think that provides the most flexibility. You will get medical directives. You will get financial powers of attorneys. You will get a will. It's called a pour of a will, but you'll also get the counseling and the titling. Okay. We charge 1/2 of 1% on the size of your net estate, subject to a minimum of 5,000. Our maximum is 13,500. Where you land on that depends on your goals, your assets, and the like, right? And so those are our fees for that. And the transactional approach is, yeah, it's less upfront typically because they're doing some documents, they're not doing any titling, there's no maintenance, and when the death occurs, you saw those fee schedules on the end. So and those plans don't work. Ours, we're not in settlement for years. Typically, it takes about a year. We're getting most of the stuff all done within a few months, but we got to wait a year for the taxes. So we're waiting on the IRS on certain things. But we got everything in the right place and we're efficient on that. And we've done over 50 administrations, trust administrations, only had to go through probate twice. And those were mini probates. And those were things that we not only pointing blame, but we had those as items that were on the clients to take care of. Well, one was a foreign asset in like Germany or Europe, and we were trying to coordinate, and things just happened. So the point of it is when you work with an attorney, one of the questions you should be asking the attorney, if they're a trust attorney and you're looking for a trust, is say, what percentage of your trust-based plans wind up being probated, right? If there's a large percentage of that, that should be a red flag to you versus, oh, 2 out of 50. Okay, this is not a normal event that happens, right? And then this side of it shows our business model is the cash flow for the firm. Our goal is we're not what I call these things called will mills, where they're trying to bring in as many clients, where they're probably bring in like 600 clients a year or 1,000 clients. We want 60 clients. Okay, so less plans, more detail work, more custom work, so that we can do the follow-up work. And so then the maintenance plan, like I showed you, has really been a loss leader, but we're just trying to break even. And it's a very nice residuals that come in to take the stress off of cash flow. And then also, and assures the team that we have a position and that, I have them, if we're not doing a good job, that you can drop. And so our service level is high because we align our interests with you. And now we're starting to see a lot of clients are referring us, which means that we're doing something right. So I don't have to spend money on marketing when we're getting existing client referrals. And then the settlement and administration is a very predictable stream. I can't predict when people pass away, but everyone uses us. They don't have to. And it's a very predictable and it's very attractive for younger attorneys to come into this system because they see that this is a long-term process. It's not a bunch of files that there's no relationship and it's going to be a mess when the death occurs. It's a very strong process. And so that builds into my succession plan. Because one of the questions I would be asking, or a lot of my engineer clients ask me is, what if something happens to you, Bobby, right? I have more clients worried about my health and welfare than I've ever had in my life. And I would be a good estate planning attorney if I didn't have a succession plan in place. So right now, I have an external succession plan, and that's with Ed Clay. He's a national network of estate planning attorneys that follows a similar model to me. And he's agreed to take over my clients when I get hit by if I get hit by the bus, and I've agreed to take over his until my internal succession plan, until our internal succession plan is fully developed. We've got junior associates, and it's about 3 to 5 years out where that is finalized, where that plan is fully, where I feel that the junior attorneys can do it. But we're on that track, so we're looking good on that. So that's my fees, probably more than you ever wanted to know about it, but those are the ranges, and that's when you ask about fees, be a good consumer on that and ask, what's involved. Is it just some documents or is it the funding as well? Who's managing that? And I'll show you our questions at the end to make sure you're asking the right questions. And then I'm a big Paul Harvey fan. He was a radio announcer. He would always say, "What's the rest of the story?" I'm probably dating, my age is older. So, but I would ask the attorney, "What are the rest of the fees?" And say, "Okay, this is what you're going to charge me up front. What are you going to charge my family on my death?" And they say, "I can't tell you that." Say, "Here's my assets. I die tomorrow. What would you charge my family?" You're probably not going to like, the answer on that. You know what we would charge. And then on disability, our disability process is so hard, it really mitigates and reduces the exposure to a bunch of expenses by being proactive. And then the death tax return preparation, if needed, is part of the deal for us. And probate services is my trick question. Ask the attorney, what percentage goes through probate. And so ours is very low on that. So to summarize, just the cost after death is those traditional probate schedules are, you saw, between 2.5% to 5% of the estate. Standard living trust planning are those Florida kind of discounted rates. We did an audit of our files. Our planning process, the cost for the life of the plan has been between 1% to 2%. And so you got to look at the whole picture if that's our approach to it. And so we're looking for like-minded people as well. And so hopefully that gives you true peace of mind. There's no gotchas or anything. It's all laid out, fully disclosed. And so that's it. I'm towards the back end of the final parts of the presentation. So I'm just comparing traditional planning versus the modern approach. The traditional planning, you get basic documents and questions answered, and that may be where you're at in life, but the modern approach is so much more. The counseling, the funding, the maintenance, the updates, those are the things I was talking to you about. Okay, so if there are things that you want to protect and are interested in learning more, then it may be worth exploring further and with our process. So our process chart looks like this, and you're right at the first part of the process, and I'll show you kind of the timelines and the like. So if you are interested in learning more, the discovery dialogue would be with one of our paralegals, probably Taylor. It's no charge. She would review your personal information form. She would give you a short goal setting exercise. She would answer some questions that she could, or get questions to us that we would have, and then give you a fee range based off of what you're looking at that point. And there's no charge, about an hour and a half for that meeting. The initial interview is with me. By stop sign means we just look at everything. I give you a specific engagement agreement, specific fee quote, scope of work, and we decide whether it's a good fit, go over everything. If it is, then we design the plan. That's that trip to the eye doctor. And then we deliver the plan. We review it, make sure you understand it, sign, witness, formalize it. Great, got the legal documents in place, done the counsel properly. Then let's get the financial integration. The financial strategy meeting is where we make sure that we have an accurate inventory of your assets, and we literally go through each asset and make a plan for each one. Any of your other trusted advisors are welcome there. It's a great one if you have a financial advisor to attend. They can come to any of the meetings if they want. And then once we have a plan, then the funding meeting is where Jenny or Taylor, our funding coordinators, will gather the magic forms to get everything in to the trust, sign that. And then there's an optional family meeting, no additional charge, as long as it's done within 6 months of the signing meeting, where we'll go over the plan as high level or as detailed as you want with whoever you want. And then you're on maintenance. So the heavy lifting is up front. People ask, how long does it take to get through the process? To get your documents in your hands, about 6 to 8 weeks. Okay, so we try to keep the pace about 2 weeks between each meeting. And then the funding process takes a little bit longer, but you've got the documents. Now it's just a matter of getting the deed coming back recorded from the county, or the financial institution sending us the verifications and the like. All right. With that being said, let me check in on the questions. And then if you all have any questions, let me know. These are the questions I would be asking the attorney. I show you like our answers. The first one is, the main thing is, please tell me about your interest, background, and experience. Just make sure you get what, hopefully you see that estate planning is enough where you don't want a jack of all trades that is just dabbling in this. How do you define estate planning? That's our definition, right? Control while healthy, plan for disability, give what I want to whom I want, when I want, in the way that I want, right? What's your counseling philosophy? That's that planning pyramid. You teach us the family, we'll teach you the law. Together, we'll work the plan. What's your process for working with me? I think especially when you're dealing with family and money, having a strong process is so critical. So that's why I showed you our process chart. And we have a process chart to get through the settlements, right? So it just walks you through it. We expect to do it. This is the big question to ask. Well, how will you counsel with me to design my plan? So I use visuals and stories. Hopefully that works for you. Number 6 is, how do we assure, this is the big one, how do we assure my assets are controlled by my instructions contained in my planning documents? That's the trust funding one. Who's responsible for this coordination, you or me? That's big. For us, it's, in our firm, it's us, okay? How do we assure that my plan stays current with changes in the law? Easy answer for us, maintenance plan. What's the level of involvement of my family in the planning process? I mean, typically, the more involvement, the better, but every family is different, so we just need to know the family dynamics. But usually communication and transparency work great. How do you charge for services, right? Specifically, how much will my estate be charged after I'm gone? So ask the questions, right? They don't, if you're thinking about just upfront, well, look at the whole plan. What's really the cost, right? And if they're a living trust attorney, the trick question, what's your record with regard to probate? What percentage of your trust-based plans wind up being probated? Do you charge differently for those, right? Do they get to charge again? Do you handle the filing of the death tax returns? That's part of our administration fee if we're hired. What happens if something happens to you? That's my succession plan. How do I prepare for our consultation? Just fill out the personal information form. What type of service should I expect from you? We have a team approach, so you'll get to different people on team, and it's not just all bottlenecked with one person. Do you expect any commitments from me? Just respect our process, our time, and just fill out the forms. And we've done this before, and we know what we're doing on this end. So with that being said, that concludes the program. Hopefully you got some good information today. I've been Bobby Fazy, president of InSight Law, and this has been Truth About Estate Planning. Thank you very much. I'll hang out for a minute or two if you have any questions that you want to ask verbally.